This lecture is a part of a series entitled Using Judicial Review to Promote Access to Justice for All. It was organized by the CARIBONO Network, the Faculty of Law, the UWI Mona, MonaLaw, and the Faculty of Law, the UWI Rights Advocacy Project, URAP. Godfrey Smith looks at the basis of judicial review in the Anglophone Caribbean and the impact of statutory reforms on the scope of judicial review in this lecture.
It is indeed a deep honor for me to have been invited to address this gathering. We are very short on time. We have much ground to cover in 45 minutes. So I think we will want to get right into the presentation as quickly as we can. So getting right in, the session objectives. At the end of today's session, if I have communicated clearly and effectively, you should be able to do 5 things. Describe the relationships between public law and judicial review in the Caribbean. Offer a view on whether there has been a public law revolution in the Caribbean. Explain what is judicial review. Describe what are the bases for judicial review in the Caribbean, and by that we mean from whence is the source of a court's power, a judge's power, to exercise the tool of judicial review. And fifthly, to identify contemporary developments in judicial review produced by administrative justice legislation and civil procedure reforms in the Caribbean. Now, undoubtedly, many of you will be seasoned practitioners. This is an introductory set of objectives. I apologize if it's very basic for you, but these are the topics that I have been assigned to address. So let's get into it. The first issue then, the relationship between public law and judicial review. As you will all know, there are 2 great bodies of law: private law, public law. Private law is concerned with the relations between that body of law governs relations as between individuals, while public law governs and deals with relations on the one hand between individuals and on the other hand between the state or between 2 different states or a number of states. If I might draw an analogy, perhaps public law can best be described as the massive headwaters from which flow mighty rivers. One is criminal law, that's public law. The other is public international law. And then there is constitutional law and administrative law. We are today concerned with constitutional law and administrative law. But in reality, is there a difference? Is there a distinction between the 2? As the preeminent scholar of administrative law, Professor Albert Fiaggio, has noted in one of his pieces, a mind-boggling challenge is the question whether truly there is any distinction between constitutional law and administrative law. Professor Wade, who many of you will be familiar with through his text, has answered that this way. He says the whole of administrative law, indeed, may be treated as a branch of constitutional law, since it flows directly from the constitutional principles of the rule of law and the independence of the judiciary. I pose the question, is the fons et origo of both simply the rule of law? Is the rule of law that supra-constitutional notion, aspect that influences and suffuses both constitutional and administrative law? Now, pay attention closely to the slide. I will not be able to give us equal time to all slides, but note that this is a very important slide because it talks about what is the rule of law. in what I think, if I recall correctly, was a 2006 case, Justice of Appeal Vitt of the Caribbean Court of Justice in the Barbadian case of Attorney General and Boyce and Joseph, said at paragraph 20 the following, and pay attention to this because this helps us answer the question about the relationship between constitutional law and administrative law. He says what is without doubt or indisputable, first and foremost, no person, not even the Queen or her Governor General, is above the law. Look at what he says next. Rule of law further imbues the Constitution with other fundamental requirements. Look at this: rationality, reasonableness, fundamental fairness, and the duty and ability to refrain from and effectively protect against abuse and arbitrary exercise of power. Now let's stop there for a bit. If you have practiced some administrative law, you will know that concepts such as rationality, reasonableness, fundamental fairness, and not acting or exercising power arbitrarily are key concepts of administrative law. In fact, they form some of the bedrock principles of administrative law. So we see here Justice Vitt at the Caribbean Court of Justice drawing on those principles of administrative law to infuse and help give interpretation and expand the interpretation of the rule of law and under the Constitution. He goes on. It is clear that this concept of the rule of law is closely linked to and broadly embraces concepts like principles of natural justice, procedural and substantive due process of law, and its corollary, protection of law. There again, clearly embracing and drawing into the fold of rule of law, administrative law concepts like principles of natural justice. He goes on then. Look at what he does next or says next. He then speaks of the right to protection of law, which is one of the fundamental rights and freedoms guaranteed under the Constitution. What does he say about that? He says that right requires not only law of sufficient quality affording adequate safeguards against irrationality, unreasonableness, fundamental unfairness, arbitrary exercise of power, but it also requires the availability of effective remedies. So there again, not only has he drawn upon established administrative law concepts to infuse and help to interpret the rule of law, one, he also does it in terms of the constitutional guarantee of the protection of law. So clearly there is a commingling, there is an intermingling, there's a suffusion of administrative law principles with constitutional law principles. I ask the question, or I consider this point, I think about this point. Lord Diplock is known in the CSU case for having encapsulated admin law grounds into illegality, irrationality, procedural impropriety. Has the time not come for practitioners of administrative law in the Caribbean to refer to the notion of protection of law and what it entails as the principle as enunciated in Boyce and Joseph? We're familiar with and talk about Wednesbury unreasonableness. Why aren't we talking about the Boyce and Joseph notion of right to protection of law and all the various things that it encapsulates? I think there's also a practical aspect to this thing. As a judge, I have had the fortune, well, perhaps the misfortune of having to deal with cases dealing with 18 different heads, grounds of judicial review. What the beauty of what Justice Vitt has done here is to sweep together a number, the fundamental principles of administrative law, and has encapsulated them in the notion of the right to protection of law. By the way, this notion of the protection of law and rule of law, which could have been considered emerging into 2006, has now been repeated and fully embraced in subsequent CCJ decisions. I can think of the Maya, the indigenous Maya case, and I think another case, Lucas and the Attorney General. But so much for that for now. So this is not to say that there's not practical differences between constitutional law and administrative law. As Professor Fiaggio points out in his important text, constitutional law establishes the principal institutions of government and allocates power between them. It allocates specific functions to bodies. So if you think about your respective constitutions right now and do a mental skip over in your mind, you will quickly remember that it deals with the executive, the governor general, the cabinet, the legislature, the judiciary, the various services commissions. Those are the principal institutions that constitute a government or a state. And what the Constitution does is to allocate power among them and describes very basically and generally what their powers comprise. What administrative law focuses on is the actual day-to-day decision making. It tries to set legal standards and principles and superintends the day-to-day exercise of those powers. So, for example, if you take the Public Service Commission, which is a creature of the Constitution, it will tell you that it has the power to appoint, to transfer, discipline. But you won't find spelt out in the Constitution what principles must inform a decision to promote or to discipline. It won't speak of natural justice, the right to be heard, the necessity to take proper and relevant considerations into account. This is how the administrative law principles fill in and intermingle and commingle with the constitutional law principles. So I hope I have tried to effectively communicate both the practical distinction, but the way in which constitutional law and administrative law are intertwined. Through the tool of judicial review, courts control the exercise of both the constitutional species as well as the administrative powers. So, for instance, in a constitutional case, you might be using, a court might be using the tool of judicial review to ensure or to check to see if a particular piece of law is in conformity with the Constitution. This can be distinguished from judicial review of actions of public officials, of public bodies, or decisions, or their omissions. But key to note, and I underscore this, again, even though there are practical distinctions, often you will see administrative law principles used in constitutional ones or administrative law remedies used in constitutional law claims. So that is the main takeaway. I hope we have seen through that brief discussion how public law relates, how the two bodies, judicial review, all interrelate with each other. Now, a bit more on the overlap. The trainees amongst us will, of course, be very familiar with the case of LaSalle and the Attorney General. If I recall correctly, that was set in the backdrop of the Black Power movement. And Lieutenant or Lieutenant LaSalle had mutinied and was brought up for a court-martial. Piece of legislation was amended for that specific purpose. And the Court of Appeal, in talking about whether his right to due process and the protection of the law had been infringed, very early on from 1971 began to speak and introduce the concepts of administrative law. So, for instance, you will see where at the second bullet point, there is the discussion of the inviolability of fair procedure, in addition to fair hearing in accordance with the principles of natural justice and administrative law concept. Also, trial by an independent and impartial tribunal, observance of the rules of natural justice, as was stated by Justice of Appeal Phillips, and Justice of Appeal Fraser was careful to point out that that was not an exhaustive code of procedural protections. It was capable of evolution and development, and indeed, that is precisely what has happened over the years to the present. In the next slide, I have listed some foundational cases illustrating overlap. I don't believe time will allow me to go in any detail with any of them. I've already referred to A.G. and Joseph with Justice Vitt. All of these 4 cases involved institutions created under the Constitution, but in which administrative law principles intervened and intermingled in relation to those particular claims. So in the case of Attorney General and Boyson Joseph, we were dealing there with the prerogative of mercy as exercised by the Barbados Privy Council, and the ultimate finding was, notwithstanding historically prerogative of mercy might not have been reviewable, and notwithstanding a constitutional ouster clause that said those actions could not be reviewed, the court nevertheless went on to say that in fact it could be reviewed. We've already adverted to some of the things that Justice Vitt and others said. In an exciting case from Barbados in the 1990s, C.O. Williams Construction and Blackman, again, at the heart of it was the cabinet of Barbados, clearly an institution, a creature of the Constitution, but in that case, the Privy Council restored the first instance decision of Chief Justice Williams, and the case established that even the Barbados cabinet was within the reach of judicial control. If I recall correctly, the principle there involved the fact that in coming to its decision on who to award the contract to, there was some evidence that a cabinet member in Parliament had uttered something that showed there was an immaterial consideration or an irrelevant consideration. And on that administrative law ground or principle, it was held that there might have been a wrong, and therefore the cabinet's decision was reviewable. You will all have been familiar with Thomas and the AG. Again, the institution there was the Public Service Commission, created under the power of the Constitution. And again, there we saw administrative law principles used essentially to say that notwithstanding the ouster clause, a high court could declare actions in excess of jurisdiction to be null and void. Reason Crane, a foundational case from Trinidad and Tobago that dealt with the judiciary, again, an institution created under the Constitution with a special exclusive machinery for dealing with removal of judges. In that case, the notion of fundamental justice, fairness, was drawn upon to come to the view that an indefinite suspension of one of the judges by the Chief Justice and the Judicial Services Commission meant that he had not been treated fairly, and that the decision to give him an indefinite suspension was unlawful. So please, with time, have a look at these cases to see how the overlap works. Another example, I'll run through this one very quickly. This is a case I sat on recently in St. Lucia. It involved two prisoners who had been in prison for in excess of 20 years. They had been found unfit to plea and basically had been forgotten in the system. In this case, I drew on a Court of Appeal, Trinidad Court of Appeal decision called Bissessar and the Attorney General, which explored whether an omission, an administrative omission by prison authorities or with whoever is the relevant authority within the state to ensure that persons found to be mentally unfit got periodic reviews to determine whether they had become fit to plead, whether the failure to accord that over many, many years was a breach of protection of law, essentially fundamental fairness. So I hope that we have communicated clearly the interrelationship, the close relationship between constitutional law, admin law, and judicial review. I turn quickly now to the second aspect. We want you at the end of the session to be able to offer a view on whether there has been a public law revolution in the Caribbean. And one of the first persons, if not the first, to have championed, advocated, and spoken about this revolution has been Dr. Albert Fiaggio. These aren't his words. I have paraphrased it, and I hope I have done justice to him in saying that he argues that the advent of written constitutions put judicial review on firm and secure foundations, unleashing public law litigation, testing the commitment of governments to the rule of law, keeping public officials in check, which only deepened with the passage of forward-looking legislation, enabling ordinary citizens to restrain the awesome powers of the state. So that was what Professor Fiaggio advocated. We will come back to that. Keep that in mind as we go through the rest of the presentation. Keep asking yourself, where is the public law revolution? How has it been manifested? We now look at what is judicial review. Dr. Fiaggio has described it as the power of courts to review laws, decisions, acts, or missions of public authorities to ensure they are within given powers. Michael Fordham, in his Judicial Review handbook, puts it this way. By judicial review, the judiciary assumes the constitutional responsibility of curbing abuses of executive power. And Lord Denning, who you will all be familiar with, who has made deep contributions to the development of administrative law, says that what it is that the High Court has jurisdiction to control proceedings of inferior courts and tribunals by way of judicial review. Your takeaway from these three experts, therefore, is that in thinking about judicial review, it's the court exercising a power to keep the executive in check or to strike down laws that are not in conformity with the Constitution. Very quickly, in an attempt to drive this definition home, or so that you understand the nature, let us ask what judicial review is not. It is not an appeal. If you have not practiced in the area of administrative law, you certainly would have done so in private law, and you would have taken matters on appeal. You know that the appeal has a statutory basis. You know that the appellate court decides whether or not the decision of the trial judge is right or wrong. It goes right into the merits, looks at what the judge does, and in looking at it, forms a conclusion whether it ought to be upheld and confirmed, whether it ought to be varied, apartheid, set aside and sent back to be reheard, whether it's set aside in toto, or the Court of Appeal may make an order that the trial judge might have made, or which ought to have been made, or any other order required. So the Court of Appeal can actually make the decision. And in many cases, the appeal may be final unless appealed further to the Privy Council or to the Caribbean Court of Justice. On the other hand, in contradistinction to that, as Professor Ventos points out in his text, in judicial review, a judge is not going and zooming in on the merits of the decision to see whether it's right or wrong, but he's looking at the decision-making process. What do we mean by that? In licensing cases or in the burgeoning number of environmental law cases where somebody challenges and say, oh, an EIA has not been properly given, or the decision-making body has acted wrongly and ought not to have issued an environmental impact assessment approval, what a High Court judge will do is look at the steps. It will look at the statute to see if any steps have gone wrong, but it is not concerned with substituting its opinion for that of the decision maker. It is not for the judge to disagree with the public body's decision, but to see whether there is some recognizable public wrong committed. And by recognizable public wrong, think back to Justice Witt's all-encompassing definition of fairness and things like whether there's irrelevant considerations and so on. Interestingly, in judicial review of administrative action, a decision may in fact be done over by the decision maker. And we saw that, or we see that in a case I've put out there. I was asked to do a case in Antigua. It involved the Commissioner of Police. In brief, he had been suspended. He had been suspended by the Public Services Commission indefinitely, and he had not been given information in relation to the reasons why he had been suspended. I came to the view that that decision should be quashed. I drew on Reason Crane, which we spoke about earlier. His suspension was indefinite. It had the effect of damaging his reputation. Even if the argument could be made that he would have had the chance later on to answer the charges, it was indefinite. There was no knowing when that would happen. The day after I finished the case, he was presented, he was suspended all over, and I think they attempted to correct the missteps. So that's an important distinction. A decision maker can redo the matter over. And then very quickly, in a minor consults, a case this time from St. Lucia, the judge said from the outset it should be stated that this court appreciates that it is a fundamental principle that it is concerned with the procedure followed in arriving at the decision and not with the merits of the decision itself. And that case also quoted Bow Valley Naturalists, which I have there. And so review focuses on the merits. Key functions of judicial review: it controls the power and duties of the government. It protects citizens against immense power of the state. It deals with issues at the intersection of law and politics, holds government's feet to the fire of the rule of law. Even bodies lacking a visible statutory or prerogative source of power is subject to judicial review if exercising public law functions or functions with public law implications and consequences. And we saw that in the Data Fin case. Now, I want to zoom in on two of these bullets, bullet 3 and bullet 4. Issues at the intersection of law and politics, holding government's feet to the fire, because this is how you empower people. This is where the revolution occurs, with the ability of citizens to hold government in check. And now let's have some fun with a case that came before Justice Westman James. This shows judicial review in action, and we see how this thing works in real life. So the backdrop to this was that some 4 months ago, on November 11th, a new government came into office. It had been out of office for some 13 years. It wanted to appoint the lady we see on the screen as its comptroller of customs, but the gentleman we see to the left was next in line. The existing controller had retired. Now, the procedure is for the Public Services Commission to make the appointment. But in this case, the government felt that its intention would be thwarted because the Public Service Commission was comprised of persons the now government thought or perceived to be appointed under the previous government, and felt they might obstruct the process of appointing the lady as Comptroller of Customs. So what did the government do? The government lit upon what it conceived to be a clever notion. It recalled that under the Belize Constitution, under Section 107, certain posts were appointed by the Governor General acting on the advice of the Prime Minister. And these included posts like Financial Secretary, DPP, Solicitor General, ambassadors, the commander of the BDF, Auditor General, and the Commissioner of Police. That section also provided that other posts may be designated as 107 posts, meaning they would be appointed by the Governor General acting on the advice of the Prime Minister. So the government said, aha, this is how we're going to go. We're going to designate Comptroller of Customs to be one of those posts, and that way the Prime Minister can appoint, the Governor General can appoint after consulting with the advice of the Prime Minister. But there was a catch. Before the Governor General could designate the Comptroller as such a post, the decision to move that position up into 107 required that it only be done after the Prime Minister had consulted with the Public Services Commission. Here is what the government did. They wrote a letter on the 24th of December, a Thursday, asking for the views of the Public Service Commission and demanding a response by the 29th. Now, if you followed your calendars, at least certainly in Belize, the 25th, the 26th, the 27th, and the 28th in Belize were public holidays. So effectively, the commission was given only one day to respond. Naturally enough, the gentleman who was next in line wasted no time in launching an application for leave before Justice Westman James, and the leave was granted. It was felt that there was an arguable case that the requirement for consultation had not been fulfilled. And there was the feeling that even though that decision of the Governor General was protected by an ouster clause, that the whole force of administrative law over the years had done away with the ouster clause protecting where there had been a failure of law or some unlawful act. So I think this case is interesting for three reasons, as I've put there. 3 bullets. Even the Prime Minister is subject to judicial review, even if it involves actions of the Governor General, protected by constitutional ouster clauses. That is not sufficient. And in that case, it also featured there was also a ground launched by the good gentleman involving breach of his right to legitimate expectations. So again, keeping in mind what our 5 objectives are, we see a commingling of administrative law along with constitutional duties in a case like this. So it's a neat case, it's live, leave was granted. I'm hoping the matter will be settled one way or the other. If not, Justice James will settle it one way or the next sometime later this month. And then, again, interestingly, judicial review. One would think in the Caribbean, where carnival is really a big thing, that matters involving entertainment are not readily the subject of judicial review. Here it was. Very quickly, at the core of this was the Public Procurement and Disposal of Public Property Act. What the Spice Mass Corporation did, which was responsible for carnival, it didn't really sell off any assets, nor did it really purchase anything. What it did was it entered into a relationship, a contractual relationship with Glenelg, a provider of water products. And the essence of the agreement was in exchange for Glenelg underwriting all promotion and advertising, Spice Mass would ensure that in signing contracts with vendors along the carnival route, one of the stipulations would be that vendors had to sell Glenelg water only to the exclusion of any others. Now, I readily confess, I am not saying absolutely that there was I am totally convinced that that methodology fell afoul of the act, but I thought it was arguable. I thought that the act aimed for, it was careful and comprehensive to bring about accountability, transparency, and so on. And I thought that it merited deeper discussion. I don't know what happened to that case eventually. It was one of the last cases I did when I was in Grenada. And if there are any Grenadians, you might be able to tell what has become of that matter. I see, in fact, time is fast diminishing, but I do want to point out this case. It was dealt with in Belize by the chair of CARIBONO, one of the co-chairs, Leslie Mendes. Again, it's interesting because refugees who one would normally think are not empowered were able, with Leslie's application, to get judicial review. It involved in a rolled up claim, unified claim, constitutional law remedies, and judicial review administrative law remedies. Now, we come to the basis of judicial review. If asked the question, you can authoritatively say, in the Caribbean, the basis of judicial review emanates from three things: the inherent supervisory power of the court, Caribbean constitutions, and legislation, particularly administrative justice statutes coming out of Trinidad and Barbados, and civil procedure rules in the OECS, in Belize, in Jamaica, in other places. That is really the source. That is the source that gives courts and judges the power to say, we have the power to review administrative action or to review laws. Now let's take a little closer look. Inherent supervisory power, as pointed out by Albert Fiaggio, Professor Albert Fiaggio, even before constitutions, courts have historically exercised the power of judicial review of executive action by literally claiming an inherent right to uphold the law and thereby control the executive and inferior tribunals. Uphold the law. Recall our previous discussion about the rule of law. And I think Douglas Mendes once described the rule of law in a presentation as even supra-constitutional, even though it existed in the supreme architecture of the Constitution. So here again, we see rule of law coming in. In Wade and Forsyth, court assumes that Parliament cannot have intended to authorize unreasonable action, which is therefore ultra vires, null and void. Dussault, cited in Fiaggio, says it's exercised, it's permissible by the sheer prescription of the rule of law. And do not forget the Caribbean cause célèbre, Hines and the Queen, which affirms supervisory power of superior courts over inferior courts. And then we come now to the independence constitutions, which really unleashed and opened the floodgates of judicial review through the supreme law clauses, which, as you know, state that the Constitution is the supreme law, and any other law which is inconsistent with it, to the extent of the inconsistency, is null and void. So if somebody wants to challenge that a law is inconsistent, obviously it has to go to a court. The court is the likeliest entity structured to do it, and the court must then judicially review it. So that is where the power comes from. Equally, the constitutions provide redress clauses, which basically say anybody who feels that one of the Bill of Rights in relation to him has been, is being, or is likely to be infringed may apply to the court for redress. So again, that is a source for the court to say, we have the power to do this, whether in relation to laws or administrative omissions or actions. And again, we say it's implied from the text of the Constitution and the concept of the rule of law. I think we've said quite a bit about the rule of law, so we will leave it at that. Again, we want to flag up an interesting case because we think that this demonstrates, manifests the notion that we are seeing a dynamism, a revolution in public law, where the concepts are being suffused, interfused together, and actually expanding to cover all aspects. Look at what Justice of Jamadar says in the Caribbean Court of Justice case of Belize International Services Limited and the Attorney General, a recent 2020 case. Let me just quickly jump down to where he says, the intent of this opinion is to interrogate how these elements of Belizean constitutionalism impact governmental and administrative action in the circumstances of this case. In the final analysis, it is suggested that as a general principle, the executive and all state and public agencies and authorities are subject to the standards of accountability and good governance that the constitutional imperative of the rule of law demands in all of their dealings with private enterprise, third parties, including, now get this, including in the making, changing, and breaking of commercial contracts. The courts, as guardians of the Constitution, are also guardians of Belizean constitutionalism and as such, agents of the people. So we see some groundbreaking jurisprudence here where the notion of constitutionalism and judicial review expands to cover contracts entered into by the governments. We can discuss this a bit later, but we have to move on now. And the third basis is statutory. Barbados introduced the Administrative Justice Act in 1980, St. Lucia, 1998, Trinidad in 2000. What is so explosive or revolutionary about this? Well, to begin with, as I understand it, even in the United Kingdom, they are just thinking about codifying grounds of administrative law. Now, before these statutes, how did practitioners go about preparing? You'd have to go to court with cases to show the judge that the kind of action you're challenging is reviewable, that the entity against which it is directed is also reviewable and subject to judicial review, cases showing the various grounds that you hope to rely on. All of that, no, much of that has been codified in these various pieces of legislation, which I think makes it far more easy to deal with these matters. Having said that, we come to the final area, which is contemporary developments flowing from those reforms. As the Attorney General of Barbados said, the AJA, Administrative Justice Act, would make Barbados the leading country in the world, certainly in the Commonwealth, in which there is an improvement in administrative justice. I've already adverted to the act. No leave was required in that piece of legislation. It introduced a conditional duty to give reasons, and it introduced lack of evidence as a ground. So we believe that codification is part of the manifestation of an explosion in public law and judicial review. It was also enacted in 1998 in St. Lucia, but not brought into force in 22 years. Why? When I asked the question, I got this response from Dr. Kenny Anthony, who was, I think, Prime Minister at the time. He says, I simply forgot to direct that the legislation be brought into force. Secondly, when the CPR came into existence, some in the office of the AG thought there were issues of compatibility. In other words, they thought the act collided with the CPR, especially Part 56. I've pointed this out to the president of the St. Lucia Bar, and she has promised to tackle this to see if they could bring what is already a piece of legislation into force. And there is the Judicial Review Act of Trinidad and Tobago, kind of mirroring the AJA of Barbados, so I won't spend much time on that. You can have a look in your spare time. Now, what has been the impact of this? I think it was neatly captured by President Michael de la Bastide, former president of the CCJ and once CJ of Trinidad, when he said, when the Bill for Judicial Review Act was presented in Trinidad in July 2000, the then Attorney General represented that the provision for the making of applications in the public interest represented a significant change in the existing law. Indeed, it would appear to have been so regarded by the legal profession and the public in Trinidad, for it produced such a flurry of public interest applications for judicial review that the cabinet was moved in 2005 to introduce a bill to repeal the section sanctioning them. Now, that's a whole nother story. There was an interesting case that came out of that. I believe at the end of the day, ultimately, the cabinet let it lie and did not interfere with it. In Belize as well, following a case, the Belize Alliance for Conservation NGOs, a case that is routinely quoted in relation to environmental impact assessment cases, the Chief Justice called out in his judgment for the introduction of a similar piece of legislation in Belize, because in that case he had to deal with the old procedures and it had been a very thorny issue. And so he called and said, much simpler. I was Attorney General at the time. I did not take a bill to Cabinet, but I remember tabling it and asking that we consider it and that I be authorized to produce a bill, but was told by the Prime Minister, no, 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 that would open the floodgates for litigation against the government. Grounds for judicial review in administrative justice statutes, I think I will just gloss over it because I've already made the point that what various pieces of legislation have done is to codify grounds as well as a number of other things, completely simplifying the process. Now, what happens where countries like Belize do not have an Administrative Justice Act, or other countries do not have it? The civil procedure reforms have been introduced, new rules have been introduced. I am careful to say it's not a piece of substantive law, so it cannot confer power of judicial review. But I must say, by and large, there hasn't been any difficulty. People prepare their applications, they do an audit with what's set out in the civil procedure rules, and those rules provide for applications for judicial review. They allow you to combine prerogative and private law remedies. They describe what locus standi, what the threshold is. It allows for joinder of other relief and even allows a court the power to allow a claim to continue in another form if it was wrongly commenced, because the whole idea is to simplify and unify. I pose the question, is there still a need for administrative justice legislation? And we can tackle that in our back and forth. So I've already adverted to the fact that private law remedies are now available in these civil procedure rules, which introduce reform. So you can get an injunction, you can get restitution, damages, return of property, and other relief. Evaluating those reforms, I think it is interesting to note that way back, Lord Denning said, and it seems like I'm slipped up in not putting the case and the year. He said back then, just as the pick and shovel is no longer suitable for the winning or obtaining of coal, so also the procedure of mandamus, certiorari, are no longer suitable for winning freedom in a new age. They must be replaced by new and up-to-date machinery, by declarations, injunctions. I say the Administrative Justice Acts and the civil procedure reforms as through the rules do precisely that and more. Which is why Chief Justice Della Bastille, we've already spoken about him, former president of the Caribbean Court of Justice, could say in 2006, and I use it as evidence of the public revolution, that public law revolution that has occurred, which Dr. Fiaggio had championed. He said, the courts are not only entitled, but have a duty to interfere with executive or administrative actions for two purposes. Look at how broadly he puts this: to prevent injustice and to secure compliance with law, above all, the Constitution. I welcome what I see as a recent trend, judges in the region showing a good deal of courage and inventiveness in the pursuit of these objectives. And therefore, I conclude by saying, since independence, there has been a deepening, I hope I have demonstrated this, deepening symbiotic relationship between constitutional and administrative law, forged, yes, by common law, deepened by written constitutions, as well as by progressive reforms, and by the judicial activism, and it seems I left out, and by public interest advocates and lawyers who have not hesitated to champion these before the courts And all of this, in my respectful view, has redounded to the people of the Caribbean community. It has offered them protection in restraining the state, and this is achieved through the tool of judicial review.